Welcome to Right Now, a new video series where Wright Lindsay Jennings' legal team explores hot topics in the world of banking and finance law. Our goal is to give you a heads up on the legal issues and challenges financial professionals should prioritize right now.
Jake Fair and Adrian Baker here with Wright Lindsay Jennings. We're here to talk today about writs of garnishment. Adrian, what is a writ of garnishment?
So a writ of garnishment is an order by a court which directs a third party to turn over the assets of the debtor directly to the creditor.
Are there different types of writ of garnishments, and if so, what are the different types?
There are different types, and it's important to know the distinctions, especially for banks. So there are bank garnishments, of course, and those have their own statutes that govern them, and they have some different rules. There's also employment garnishments, where an employer garnishes the wages of an employee and turns over a portion of wages to the creditor. And then there's also other, what I'll just call generic garnishments, and that would be a garnishment, any other type that's not a bank garnishment or an employee garnishment. And that's where any third party can be directed to turn over assets of the debtor to the creditor.
So if I'm a bank and I get a writ of garnishment, what are some things I need to think about and do in response to that garnishment?
Sure. Well, the first thing that a bank really needs to do is have a written procedure in place for how they're going to handle garnishments. And that's because, as we'll talk about in a few minutes, there are big liabilities and big exposures to a bank that doesn't comply with the law on responding to writs of garnishment. So the first thing that a bank needs to do is to make a note of when the garnishment was received. And I mean exactly when it was received. Day, if you can collect the time, that's important too. And that's because when you are served with a writ of garnishment, it creates a lien on the assets of the debtor from the moment it is served. And that means the bank is under an obligation not to release any of those assets, technically from the moment that that writ of garnishment is handed to your registered agent or whoever is accepting the service of process. So the bank needs to have a process for intake. Then the bank needs to search its records to determine if it has any accounts of any type for the debtor, if the debtor is an employee of the bank, or if the bank owes other money to the debtor. So for example, if the bank uses Joe's Lawn Service to do its landscaping at the main bank branch and they get a writ of garnishment on Joe's Lawn Service, it's not sufficient to see if you have a bank account for Joe's Lawn Service. If you owe Joe $500 for mowing the lawn, now you owe that to that creditor.
Oftentimes I've seen financial institutions have processes that are really outdated. And what I mean by that is they're using Excel sheets. There's one person responsible for doing all these tasks. There's not a documented process. Are those all things that you can help with? And when a bank is thinking about what process they should be implementing, is there any recommendations you would give in that regard?
Absolutely. I would say that hiring competent garnishment counsel that has extensive experience dealing with writs of garnishment is the best thing you can do. And as a bank, your outside garnishment counsel can help you develop a written procedure for your employees to follow. And that way, it doesn't live in the institutional knowledge bank, which is dangerous for any company. So I would say get outside garnishment counsel to help you prepare your internal procedure. And then if you want, that same external garnishment counsel can also file the responses on behalf of the bank.
So a minute ago, you mentioned noting the time and the date when a garnishment is received from a third party. And what are the consequences of not timely responding and not taking some action right when you get a garnishment?
Sure. There are big potential consequences to failure to comply. What a lot of banks and other companies don't know is that they are required to file a response with the court to every single writ of garnishment. Sometimes you may get a letter with the writ of garnishment that comes from the judgment creditor's attorney that says, send me a letter or just fill in the blanks and send it to me. That's not sufficient. The law requires that every time a bank is served with a writ of garnishment from a court case, that the bank have a licensed Arkansas attorney file a response on behalf of the bank. If a bank fails to do that or fails to do that in a timely manner, the court may enter a judgment in favor of the bank for the full amount of the debt. What that means is if you get a writ of garnishment on Susie Q and you don't have an account for Susie Q and you don't know who Susie Q is, so you just ignore it, but Susie Q owes the judgment creditor $100,000, well, if you don't respond, the court may enter a judgment against the bank for $100,000, and now that is a debt of the bank.
Yeah, and what's interesting about that, Adrian, is I've seen some lawyers and clients that will say, well, doesn't the statute in Arkansas say that you're only liable up to the amount that you were supposed to hold? So in the example you just mentioned, if there's no account or you don't have any money belonging to that individual, then you would not be liable for anything. And I think that's a fair resuscitation of the law in Arkansas. The problem is I've seen multiple situations where there's some other factors that go into it, like requests for admission that the bank also fails to respond to. And there is a procedure by statute which people have to go through to get a judgment against that garnishee. But I see a lot of confusion by courts and judges and parties alike on that issue. So I don't think it's as simple as saying, we don't have an account, so we're not going to be liable for anything as to this person. Do you think that's fair?
Absolutely, I agree. And I've personally been involved with lawsuits where that happened. And you would have, one attorney telling the court, well, the statute says that I can get a judgment for the full amount. And when the bank doesn't participate in that proceeding, then it doesn't have an advocate there to tell the judge, no, you need to look at this other statute. Yes, this one statute says this, and it suggests that they can get a judgment, but if you read further, there's another statute that says that they really can't. So as in many areas of the law, the statutes governing garnishments in Arkansas are not a model of clarity. So I've seen multiple situations where courts have entered multi-million-dollar judgments against non-responding garnishees.
So as banks think about this and how can they minimize their expense in responding to garnishments while complying with Arkansas law?
Sure. And we know we work with banks on this all the time. This is an annoyance. It's one of those costs of doing business that nobody wants to pay, but it's a necessary evil. So we have extensive experience working with banks to come up with their internal processes and procedures that can not only streamline things internally, but also minimize the involvement of outside counsel to reduce the expense. So for example, I have some clients who they have their procedures, they prepare a packet internally of information, they do everything, including preparing the response, and then they send me the packet with everything completed. And all I have to do is review the packet, confirm that the response they've prepared complies with the law, and then I can sign it and file it. That is completely compliant with Arkansas law. It minimizes the need for my involvement, and it gives the bank certainty that they are following the law.
So we've all seen this where the bank sends in a one-page response, or any garnishee sends in a one-page response from the payroll director, or for banks it's oftentimes a back office person. Is that letter compliant with Arkansas law, or is that deficient?
That is deficient under Arkansas law. The Arkansas Supreme Court has said that anything filed by someone who's not a licensed attorney on behalf of a business is a nullity, which means it's just as if he filed nothing at all. Now, 9 times out of 10, is this going to come back and bite you? Probably not, at least if it's a very small dollar amount, because your judgment creditor is probably not going to want to go through the fight of arguing that your answer is a nullity and didn't comply with the law. But there certainly are cases where it's a bigger amount in controversy, for example, a garnishment for $75,000 or $100,000 plus dollars, and the bank has its HR director or someone else file a response, and the judgment creditor argues this is a nullity, the bank is in default, and the court agrees. So to answer your question, no, those are 100% of the time not acceptable.
Are there any other tips you would like to give banks on complying with garnishments and just the current state of the law in Arkansas?
Sure. My tip, unfortunately, is that garnishments, while they may seem pretty straightforward because they happen all the time, are a minefield full of pitfalls for the unwary. It is a highly technical process governed in part by statutes and governed in part by case law from various courts in Arkansas that is not always perfectly in alignment. We, over the years, have developed expertise in what the law is because we've had to live in this area for so long and analyze this law. But it's not simple for someone to just, pick up the Arkansas code, read the statutes, and know how to do it. And that's evidenced by the fact that I would say 99% of the writs of garnishment that I respond to on behalf of banks are not served properly. And even though some of the creditors and their attorneys serve thousands or tens of thousands of garnishments per year. They never serve them correctly in compliance with the law. So if you can have experienced garnishment counsel, they can save you from some heartache by, for example, knowing when and how to assert an objection on the basis of improper service.
And my advice, Adrian, generally to banks is process, process, process. So practically, if you can focus on what your internal processes are and have guidelines that your associates comply with, and then work with outside counsel to make sure answers are correctly filed, then you're going to be way ahead of the curve, and you're going to be in good shape. But it's been my experience that most organizations, big and small, most banks, big and small, don't have the processes in place and need help with that aspect of it. This has been a great conversation. Thank you for your time today, and thank you for watching right now.